So why is this ruling from the Supreme Court so significant and so historic? Let's tell you about what changes it's brought about in the country, what the abortion legislation stated previously. We're talking about the Medical Termination of Pregnancy Act, the MTP Act, which has been debated about a lot. So the abortion laws previously, before the Supreme Court ruling, stood as this. It said very clearly that with regards to married women, yes, abortions can happen. But the legislation made a distinction between unmarried and married women. So before the Supreme Court's intervention, medical termination of pregnancy was in fact allowed for married women. So that was something that was okay. Now after also it's still very much allowed, the Supreme Court has of course said that there can be no distinction. From 20 to 24 weeks the fetus can be aborted. But here's the biggest point. Before, this particular act said no termination of pregnancy for unmarried women. Now it's allowed for unmarried women as well. And the Supreme Court very importantly has said that we need to get out of that notion, that stereotype that unmarried women don't indulge in intercourse. Now beyond that, another big point is that the Supreme Court has said all women, irrespective of whether they're married or unmarried, if they're in a consensual relationship, are entitled to a safe legal abortion. That distinction that was made on character, on whether they're married or unmarried, has been taken away, has been gotten rid of by the Supreme Court. Now, to understand this legally and what this means going forward also, I have Aishwarya Bhati, Additional Solicitor General of India, Senior Advocate of the Supreme Court. Aishwarya Bhati, thank you so much for taking the time out and joining us. Good evening. To you, why is this verdict that came in from the Supreme Court today so very significant?
Well, it is a significant verdict for any woman in India, but it is especially significant because my office was asked to assist. The Honorable Court had asked us to assist, and we were assisting the court in laying down this judgment, coming to these conclusions. But I do have to say, I was listening to what you were saying. The distinction was not there in the MTP Act between married and unmarried women earlier. In fact, the 2021 amendment in the Medical Termination of Pregnancy Act that was brought in, that had substantially liberalized the provisions that were existing. The distinction was there in the rules under the Medical Termination of Pregnancy rules, which is Rule 3B, which has been held to be unconstitutional by the court. There the distinction was there. So medical termination of pregnancy was available under a statutory right, has been always available to Indian women since 1971. So we are a progressive country in that sense. The right has been available to all Indian women, irrespective of their marital status. What was happening was between the period of 20 to 24 weeks, only women who were in extremely vulnerable categories, they were allowed to terminate their medical pregnancy. Now, Rule 3B of the MTP rules prescribed who those 6 categories of women would be. And one also, the other categories are, victims of rape, victims of human tragedies, minors, women who had mental disabilities in any form, etc. And there was one category in that which prescribed that if women had a change of marital status, and in the parenthesis, in the paragraphs, it was written, when a woman becomes a divorcee or a widow. So it was only that portion that the court was interpreting in the rules, but the court has struck it down. We also assisted the court to read it down in this. We also brought out the aspects of purposive legislation, because a change of marital status cannot mean only a woman who undergoes a divorce or who becomes a widow. Even to live in relationships in India have the protection of the statute, have the sanction of the statute. So to leave unmarried women out of this extremely vulnerable categories, so as to enable them medical termination of pregnancy between 20 to 24 weeks was what has been considered. And the findings and the ratio of the judgment is extremely reformative. Like you rightly pointed out, I think the US Supreme Court needs to look at our Supreme Court today and realize what they are doing with their women, because right to a reproductive choice, the Supreme Court has categorically held again. It goes to the woman's dignity, it goes to the very basic personal autonomy right of a woman, and it is available to every woman who may need access to safe medical termination of pregnancy.